Am I audible now? The voice clear, everyone? Okay. So my video and audio both are clear for you, everyone? Okay. So let's begin. Very good evening, everyone. So with regard to the Super 35 classes, as I already said to everyone, just I wanted to reinforce the intention of this Super 35 sessions for the CA inter examinations. These Super 35 lectures, what I am going to provide in my YouTube channel, are relevant not only for the Jan 25 exams, they are relevant also for the coming 1 year examinations, because only that extra new question paper will get added, because we are going to make a question answer discussion which doesn't change across any attempt. 1 year is the validity of these questions and answers. Even for next to 4-5 years also these are valid, but good amount of 20-30 new questions will get added now. That's why. So for Jan 25, those who are attempting for the May 25, and those who are attempting for September 25, for all these attempts, these Super 35 lectures are relevant. Okay, so that's the point number one. And second very important thing, what is the importance of the Super 35 lectures, how this will be helping you? Let me first put clarity also on that, how this particular session is going to help you, the Super 35 revision session. Number one, I will tell you this way, it will be taking around hours of time of the student if he have to start studying the question bank of his own. And moreover, what are important points, what are the important sentences which we need to quote in examination, generally student will always leave. Therefore, with that intention, what I am trying to do is, I will first show you the questions and answers. Okay, I will first show you the questions and answers. After that, I will tell you how to present it in exam. Maybe everyone out here who are attending this live session may think, sir, I am good at law, I will understand everything, but I am not able to go get more than 50 in examination or more than 40 in examination. I know everything, sir, whatever you said I remember, but still I am having a problem in writing the answers in exam. So how come this session will be helping you? The thing is, Super 35 sessions are coined with an intention that you will be guided towards a success journey with regard to the law in such a way that we are going to take the questions from the past examinations, study material, RTP, MTP, and study material. We will take the questions. There are lot many questions I kept in my question bank. So we are not going to do each and everything. We will do every question, but some questions we will give more importance. Some questions we will give less importance at the end of the session. I mean, at the end of the chapter, what we will do is we will write down all the important questions which you need to refer from the exam's point of view. So at the neck of the moment at the time of exam, what we need to refer, students are first not having a clarity on that. So that we are going to take here. Clear everyone? Did you understand what I said everyone? This session is a question answer discussion session wherein past examination RTP, MTP study material, every single question we are going to study. And at the end, we are going to write down the questions which are very important such that at the last neck of the moment, you will be completing them. Clear? I will be constantly in touch through my mobile. If you have any doubts, you can put a message also. I will clarify. Okay. So first thing, this particular Super 35 discussion will be completely 100%, okay, will be there completely from the question bank, the latest question bank. Through that only I'm going to take all the questions and answers. Okay, so let's begin. So let me answer the questions first. After that we will begin. Good evening, good evening, good evening. Hi, 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 hi. Va talaiva from Nandri. So Super 35. Sir, why are there no law recorded lectures available on Pathshala website? New law lectures will be available in another 2-3 days maximum. Okay, maximum, not even 2-3 days, but tomorrow itself live will come also about that. The new law lectures also will be coming for the next exams to come. Okay, let us begin. This is not the time to talk about the regular lectures. Let us first concentrate on the examinations that are held up in Jan 25. Okay, let's start. But please, everyone, I am requesting you, please be supportive. Answer to the questions as well. First one, we are going to start with, as I already said, management and administration. This chapter we are going to begin. Reason, the highest marks weightage is there. Okay, what weightage? Highest marks weightage. I will show you one stat. With that, you can understand why we started with this. See this. See the statistics. Hopefully, is it visible, everyone? Reply. Whatever I am showing on the screen, is it visible for you? Are the numbers visible? Okay. You see the importance and trend. First, you see management and administration chapter. 19 marks, 14 marks, 20 marks, 9, 4, 8, 19, 15, 7, 4, 8, 12, 13. When so much of good amount of marks are being tested in this chapter, why we should not consider this for the first? With that intention, the first chapter that I am going to consider is management and administration. Okay, first everyone who joined live, say yes or no. Did you understand the importance of this chapter or not? Okay, yeah. Those who have taken the question bank, just wait till Monday, means tomorrow you will receive all your question banks as well. Okay, okay. Sir, again I'm telling you, please, viewers who are watching live, please watch it live. Just like a cinema, between cinema advertisement, like don't change the channel, coming to YouTube, listening to the lecture, going back again. I will tell you one thing, I will unlist the video once it is completed. So that seriousness should be there from the students and also, because I am putting a lot of efforts and taking the class, means there is no point of attending, changing like a TV remote, one channel to another channel, coming back again one channel to another channel. Please, I don't wanted to do that. sessions, you should take it very seriously. Okay. So tell your friends also who joined live. Once the video is completed, once this lecture is completed, it will be unlisted again. So please make sure that you are listening during the live. So listen. First one, we are going to start with the area called as management and administration. In simple and in short, people call this as general meetings chapter. Why? In management and administration, there are two segments. Segment number one, registers and annual return. Registers and annual return. Segment number two will be general meetings. In exam, 95% of the times, questions are coming from general meetings. Therefore, substantial part of this chapter is covered by general meetings. People call it as general meetings chapter. Okay, but actually no, questions, even 4-5 times questions also came from first part of this unit as well. One by one, let us see. Again, how we are going to approach towards this Super 35. Whenever I take a question answer, from that point of question answer only I will discuss. This is not a regular session. I can't explain the concept to background, everything again. In the revision session means it should look like revision session only. Students should not waste even a single minute of time. Once we complete an answer, go to the next answer. That's it. I will give time for you to read the question. But when you answer, ensure that you are answering it perfectly. Okay, let's begin. Choose the correct answer from the following and give the reasons. An index of members must be maintained by the company when the membership exceed 20, 50, 70, none of the above. What is index of members? List of all the members in the company. List of, I'm scrolling because don't see the answer. List of all the members in a company. List of all the members in a company. Whoever is coming in as a member, who is going out, who sold the shares, who bought the shares, index will be maintained. Index means the details, the summary of all the synopsis of all the members of the company will maintain in a document called as register of members. Okay, so register of members should be maintained even if there are two members. Yes, so number is irrelevant. 20, 80, 70, 60, this is not the criteria. Even if it is a private limited company having two members, you have to maintain the register of members. So none of the above. So it's not 20, it's not 50, it's not 70, none. Why? Reason also I have given. This is a 2 marks MCQ question which is tested. Okay. So November 2010 it was tested. Recently in MCQ also this came. Under section 88.1, every company is required to maintain. Every company, public as well as private. Private some exceptions are there. We will discuss later. Okay. Is required to maintain index of members. Index of members. Regardless of number of members. So number of members is not the criteria. You have to maintain the register of members. And one thing, since this is a YouTube live session, an interactive session, I want everyone to be interactive, answering my questions and queries that I put before you. Okay. First tell me everyone fastly. Did you understand question 1 and the answer? Okay. Okay, done. Next one. Next one. Question number 2. May 2018 question. As per the provisions of Companies Act 2013, every company is required to file with the Registrar of Companies the annual return as prescribed in section 92 in form MGT 7. Explain the particulars required to be contained in it. Okay. Simply he is asking what are the contents of an annual return. Okay. See here. In this chapter general meetings, there are two types of document. Number one, annual return. Number two, financial statement. Financial statements are contained in section 137. Annual return is contained in section 92. Okay. Everyone, Purinda, understood everyone? So annual return is in section 92. Financial statements are in section 137. 92 annual return will contain the full particulars of what happened in that 1 year. Okay, simply to tell, it is a event return. It is a event return. What is event return? What are all the important events happened in that particular company, and some other crucial details about that company you will be having in the annual return. Okay, people will get a doubt now, sir. I will have the details of company, etc. All these things also in other documents, no, sir? Yes, I will tell you one thing. If you wanted to know, okay, if you really wanted to know about what are the objects of the company, which document you should see? Memorandum of Association or objects clause you should see. Or the one document. I wanted to know what are the powers of management directors of the company. What directors can do in that company, I wanted to know. What you need to do? Articles you have to read. Correct or not? Where company is located, where to see? Again, you have to go to the Memorandum of Association. Okay. Memorandum of Association, you have to go. No, sir, I want exact address of the company. You need to go to website and search. Online, you have to make a search. Correct or not? Who are all the directors of the company? I want the names of all the directors. Again, go to website. Simply what I wanted to tell you here, thing is, if you wanted to know the details about a company, there are various places where information is available. MOL has some information, AOL has some information. Okay, some part of information is available on website, some part of information is available with ROC. No, members don't want confusion like that. I want everything in one place, like our question bank. RTP available, MTP somewhere available. Okay, study material again separate book. But how beautiful it will be if I can bring all these into one single question bank. Same question bank logic, annual return logic. I don't want member to search so many places here to know about my company. Ease of access. Okay. Therefore, every single year, every company within 60 days from the date of AGM. Once the AGM is concluded, within 60 days of from the date of AGM, company has to file annual return in form MGT 7 with the ROC giving these details. Okay, these details you have to provide. Or so much big questions are dead easy questions are. Okay, let us see what is the content. Okay, so first everyone reply all those who are joining live. Understood? Again, I'm making it very clear. All the students, please don't blame me after that. Once live is completed, video will not be available. Ensure that you are listening and completing here itself. Please continuously put an effort, understand the concepts. Because anyway, question bank, you need not revise anything. So I will explain each and every question very clearly in detail and I will move on to the next one. So please ensure that you are listening properly. Okay. Now next. So now what are all the contents of annual return? What are the contents of annual return? First one. Annual return. As I said, now, I wanted to know where my register office is located. Check the annual return. Okay. I want to know the objects. Principal business activity. I wanted to know what are all the group companies for this. Group companies means, see here. Every company will have 4 kinds of group companies. This is our company. Above you, holding. Below you, subsidiary. Along with you, associates. Okay. I wanted to know the details. These details also will be available in the annual return. Means what is my company's holding, subsidiary, associate. So everyone, now revise. What will be there in the annual return? Number one, the registered office. Second one, principal business. Third one, group companies. Group companies means holding, subsidiary, and associate. Number two, how many kinds of shares your company is having? Okay, 10% par value shares, 100 rupee par value shares, okay, 50 rupee par value shares. How many types of shares you have? How many types of debentures you have? 9% debentures, 7% debentures, 8% debentures, 11% debentures, 5% preference shares, 9% preference shares, 10% convertible preference shares. Along with that, you should give me the shareholding pattern. Means in the entire shareholding, how much is held by promoters, how much is held by what to say, qualified institutional buyers, how much is held by directors, how much is held by employees, how much is held by government if any, how much is held by banks and institutions, how much is held by public. All these things you need to clearly give. So the shares, debentures, and other securities, preference shares, etc., and shareholding pattern. Revise everyone. Number one, registered office, principal business activity, holding subsidiary associate. After that, shares, debentures, other securities, and the shareholding pattern. Number three, its members, debenture holders, along with the changes therein since the close of the previous financial year. Its members and debenture holders, along with the changes therein since the close of the previous financial year. Means how many members were there, how many debenture holders were there 1 year before and 1 year after. This is called comparatives. This is called as a comparatives. Okay, so the numbers, debenture holders, along with the changes happened in the last 1 year. Next, now members over, member debenture holder. Next, management will start. Promoter, director, KMP, along with the changes made in the previous financial year. Next, members over, directors over. Now meetings will start. Meeting of members, meeting of board, meeting of committees. Once meeting is completed, if it is a board or a committee meeting, you have to pay remuneration to the directors for attending it. That's called as a sitting fees. So remuneration of the directors, remuneration of KMP. So now 1, 2, 3, 4, 5. Okay, 1, 2, 3, 4, 5, 6. 6 points we completed. Let's revise. What are all the details we need to quote in the annual return? The registered office place, the principal business activity, the group company. Group company means what we need to mention? Names of the holding company, subsidiary company, associate company. Next, come to the instruments in the company: shares, debentures, other securities, including shareholding pattern. Number three, members, debenture holders, along with changes in the last 1 year. Directors and KMP and other people, along with the changes happened in last 1 year. After that, meeting of members, creditors, directors, and next one is the remuneration paid to the directors and KMP. Up to here, everyone has a clarity? Up to here, everyone had a clarity? You're clear? We will move on to the next one. Okay. So, penalty or punishment imposed on the company, its directors or officers, and details of compounding of offences and appeals made against such penalty or punishment. This is important here. Please listen carefully. I will explain the meaning of the words. This is not the time to understand the concept. This is the time to learn the impact of this question. Penalty or punishment imposed on the company. Okay, first, if there is any penalty or any punishment imposed on company, directors, officers, anyone. When I say officers, KMP, everyone will come into this. So any kind of penalty or punishment is imposed along with the compounding of offenses. Sir, what is compounding of offenses? I'm not interested to go into the details of compounding because it takes a lot of time. I will explain an overall idea. Compounding is a concept where people are not interested to go to jail. Okay, for example, there are two types of consequences here. Whenever you are going into the jail, jail can be given to a person because it will, the intention of a jail is to keep him in isolation. Financial fraud was done. Which fraud? Yeah, financial fraud was done in the company, but unknowingly it was done. It was not done knowingly or not intentionally. Unintentionally, financial fraud happened in the company. Okay, they don't know that it should not be done. I will give you an example. As per section 185, not in the syllabus, just explanation. There is a section called as 185. Section name is loans to directors. Loans to directors. As per section 185, company should not give loan to directors. Okay, I don't want to repeat here. Let's not waste time. Company cannot give loan to directors. If given, it is a punishment. 6 months imprisonment is also there. Okay. One day, one of the director took money from the company as a loan with the intention to repay back. He don't know that there is a section in Companies Act called as Section 185 which prohibits the loans to director. He don't know. He took the loan. One day after, chartered accountant came to the company. He is checking all the entries in the last day. He saw a loan to director. Immediately asked the director, "Are Muttal, don't you know that you should not take loan?" He said, "Sir, I don't know." "Hey, give it back to the company." Immediately, day 2, he gave loan to the company back. I mean, the loan was returned back to the company. Okay. One day he has taken. Second day he came to know that it is an offense. Immediately he gave back. And his intention is very good. He's not having any malified intention. But do you know what happened? Amount transferred to you or not? That's it. Section gets attracted. 6 months imprisonment is unlocked. Immediately court sent you a arrest order. Arrest him because he has violated provisions of Companies Act. Now you can apply for compounding. Compounding is a mercy. Yeah, court. Please, Shama, leave me. Please don't punish me with imprisonment. Okay, because I don't know that I should not do like this. By mistake, it has happened. You can check my past track record. I'm a clean person. By mistake, it has happened. So please, I request you not to imprison me. Lift the imprisonment on me. Court will understand. Okay, understandable. So therefore, pay 5 times the fine, 2 times the fine, 1.5 times the fine, and I will what to say this relieve you from the imprisonment. For example, under that section, if the fine is 1 lakh, instead of 1 lakh, I will take 2 lakh. With that extra 1 lakh, imprisonment will be relieved. Understood? That concept of paying fees to escape from imprisonment, we call as compounding of offense. Understood the concept, everyone? Compounding of offense meaning? Reply, everyone, reply. Don't sit idle, reply. Okay. Sir, I am checking for any messages from the students. If you have any kind of doubt, you can put me a message. One person already kept a doubt. Sir, we need to compound a penalties and everything. It's always option. If you want, you can. If you don't want, you need not. Compounding is not mandatory. Okay. Let's begin now. So, registered office, principal business activity, particulars of holding subsidiary, associate, shares, debentures, and other securities and shareholder matter, members, debenture holders, promoters, meeting, remuneration, penalty, compounding of offences. Sometimes department levy penalty and MCA will levy penalty, ROC levy penalty on you. You said, "Arey ROC, why you levied penalty on me?" Okay, ROC will send, "This is the reason." You said, "No, I did not do that. Why you levied?" Challenge the ROC now. Challenge the ROC. Where RD, you have to go to a higher authority and challenge him. That concept of challenging lower authority on a higher authority, we call as a appeal. Appeal is like a reference that we take from cricket matches. Whenever a person was out but umpire is not giving, now we will ask, I will go for reference. So that concept a appeal. Next, matters relating to certificate of compliances, disclosures as may be prescribed. These are all not required here. Up to G point you have to write in exam. A to G. Examination, this question will come for 4 marks. How many marks? 4 marks. At least you need to write 6 points to get that 4 marks. Okay. 1 minute time for you. Revise the answer properly. We'll go to the next one. From the next question onwards, I will increase the speed also. This question is new for you. That's why I'm taking it very slowly. Can you move on to the next one? Let's continue. Next one. Okay. Listen. Let us read the question first. May 2018 question number 3. Let's begin. Bazaar Limited called its AGM in order to lay down its financial statement for the shareholders' approval. Due to the want of quorum, the meeting was cancelled. The directors did not file annual returns with registrar. The directors were of the idea that the time for filing of returns within 60 days from the date of AGM, I told na, MGT7 you have to file within 60 days from AGM, okay, would not apply as AGM was cancelled. Has the company contravened the provisions of Companies Act? If the company has contravened provisions of Companies Act, how it will be penalized is a question now. Clear? Read it. When I ask you to read the question, you are in the verge of your exams. Be honest, read the question only. Okay? Don't fool yourself. Read the question, try to understand what he is asking. Same questions will come in next exams also. So how honest you are, that much successful you will be in the coming exams. Read the question. Half a minute time. Okay, let us begin. Bazaar Limited called its AGM. I will summarize the question now. First, let us understand what to write in exam. When a question comes, it is 4 marks question. Yeah, how to present it? First thing, whenever there is a question that is tested, first thing, don't write your conclusions and answers. First, write down the provision. What is said in the law? First, write down that. After that, other drama you start. Directly in the given case, don't write like that. First provision. For this only they will give marks. Okay. For this 4 marks, for this 2 marks they will give. For your conclusion, another 2 marks will come. Okay. Depends on the type of question. So let us see. What is this section all about? Let me explain first. There is a section called as a 92. That section says like this. Annual returns must be filed with the ROC within 60 days from the date of AGM. Okay. Sir, AGM may not held or AGM is cancelled. See here. Due to want of quorum, meeting was cancelled. Which meeting? Annual general meeting is cancelled. Okay. So annual general meeting is not held. If annual general meeting is held within 60 days from annual general meeting, you have to file it with ROC. They said directors did not file annual return. Okay. ROC sent a notice putting a penalty. Pay penalty, you didn't file. Then directors are saying, Are ROC, we did not file. True, correct, 100% right. Why we did not file? Because our AGM is cancelled. Our AGM is cancelled. Since AGM was cancelled, AGM is not held. Since AGM is not held, 60 days from AGM concept doesn't apply to us. Okay, but section says like this. There is a section called as section 96, AGM section. AGM section gave 3 dates. Whichever is earlier should be the date of AGM. Whichever is earlier should be the date of AGM. Whichever is earlier should be the date of AGM means, what do you mean by that? There are 3 dates given. Okay, those are the due dates. 1 date, 2nd date and 3rd date. Whichever is earlier. Say for example, 1 date came as 39. 1 day came as 10/10. 1 day came as 31st December. Okay, which one you take? Whichever is earlier. What is the earlier one? 39. So 39 is the last date for holding your AGM. If you conduct your AGM beyond this date, you are contravening the provisions. You are not complying, penalties will be levied. In the given case, same thing happened. AGM is not held. Therefore, they said, director said we did not file. But section 92 says that if AGM is held within 60 days from AGM, you have to file annual return. AGM may not held within 60 days from the last date on which AGM should have been held. Okay, what is the AGM should have been held last date? 39. From there 60 days you must file annual return even though AGM is not held. Now question will come, sir, AGM may not held means what annual return I will file? Don't file annual return. File the reasons for not holding the AGM. Okay, see, as per section 92.4. Okay, section 92 is the topic. As per section 92.4, every company and public, private, both P&P shall file with registrar a copy of annual return within 60 days from the date of AGM, or where AGM is not, no AGM is held within 60 days from the date on which AGM should have been held. Okay, together with reasons for not holding AGM along with the fees. How to file. So even though AGM is not held, last date on which AGM should have been held from there 60 days. Next, in the given case, what happened? As the company contravened provision, the directors were of idea that time of filing within 60 days would not apply. Directors right or wrong? Now you tell the answer. I will wait. You tell the answer. Those who joined live, tell the answer. Directors are right or wrong? Yes. So the director's contention was completely wrong. Okay. So the directors of Bazaar Limited did not file annual returns as they were of idea that all the question we have to write again. Present case. Finally, conclusion. Thus, the directors have contravened provisions of 92 and penalty will be as per 92 subsection number 5. 92 subsection number 5. Sir, what is the penalty under 92 subsection 5? See here. In my book, I kept all penalties in the appendix. Let me show you. Minute. Okay. Okay. See here. Appendix 2, the penalty chart. Chapter wise I kept. Management and administration 92 subsection number 5. Okay, let's see. Who is liable if annual return is not filed? Important for exam. Where company fails to file even within 270 days from expiry of 60 days time limit. Means what? 60 days over. Within 270 days also it did not file. And means fails to file within 330 days. Penalty shall be as under. Company and officer in default shall be liable to a penalty of 10,000. Even if it continues, 270 days after again it continued. For each day, 100 rupee penalty. Maximum will be up to 2 lakh. Okay, this is company ki penalty. What is the penalty on the officer? 50,000 in case of officer. Sir, how to understand this? If company has not filed financial statement, if the company did not file annual return within 60 days, if it did not file, what will happen? If the company did not file the annual return within 60 days from the date of AGM, okay, you have to file it anytime within 270 days by paying additional fee. Okay, within how many days? 270 days. From the AGM date, if you take 270 plus 60, 330 days. That's why I have clearly given fails to file within 330 days of date of holding AGM. So, for the first 330 days, penalty not there. You have to pay additional fees and file. even after 270 days, if you do not file, okay, then what will happen? Such a company and every officer will be liable. How much on company? 10,000 rupees will be flat penalty. Along with that, how many days after 270 you prolonged? 30 days, again another 30,000 up to maximum of 2 lakhs on company. Okay, maximum of 50,000 on the officers in default. Okay, because this is not a biggest crime. Now, just I did not file a document, but on a document 1,000 rupees every single day on company. Okay, every single day on director, but maximum will be up to 2 lakh for company, 50,000 for the director. Now you please give a reply. Everyone understood? Hmm. 1 minute, I will put it before you. Please read this properly. Question also you see one more time. Answer also how to present. First day session I will be little slow. I'll explain how to present and answer. From then, once concepts are completed, we can increase the speed. Okay, done. So with this, we completed section number 92. Question number 3 also completed. So before we move on into the next one, I just wanted to make a small, what to say, small rectification for this. This is 100 rupee per day, not 1,000. I'm very sorry. This is 100. Further penalty of rupees 100. Flat penalty of 10,000. Everyday penalty will be 100 till it continues and reaches that particular 2 lakh. And on the company, it will be 2 lakh maximum. And on the officers in default, it will be 50,000 maximum. Next, question number 4. Messrs. Techno Limited maintains its register of members at its registered office in Mumbai. A group of members residing in Kolkata want to keep the register of members at Kolkata. Explain with the provisions of Companies Act 2013 whether the company can keep the registers and returns at Kolkata. Does Mr. Ranjit, director but not a shareholder of the company, have the right to inspect the register of members? Is the query. Please read the question before we go with the solution. Please read the question, everyone. Read the question. They can directly come in examination in the next coming attempts. So please, question man, take it seriously. Okay. Now, let's go into the answer. So see here. Register of members is the details containing all the names of the members, their shareholding, etc. All the details will be contained in a register called as a register of members. Now the question is on where to keep the register. Where to keep the register? Always try to understand the word register came from the concept of registered office. From the registered office. And generally all the registers relating to the company, all the registers should be will be maintained by the company at the registered office. Okay. Now the question. So register should be kept only at registered office. No need. There is an exception for that. A proviso is inserted. Do you know what section said? If, I will repeat one more time. If in any particular place, if in any particular place there are more than 1/10 of the total number of members entered in the register of members reside in a place, with the approval of special resolution, we can also place at such other place. Sir, I did not understand. I will explain you. See here. I will take another page and I will explain. See here. My company registered office is in Hyderabad. Okay. Company registered office is in Hyderabad. This company has members throughout India. Everywhere, north, okay, west, east, south, everywhere members are there. Okay. But mostly people are located in Hyderabad. Mostly. Because companies from that particular place, most of the shareholders are from that place. However, in Chennai, okay, however, in Chennai, 12% of the members are also located there. Means a good amount of members are located also in Chennai or not. So therefore, giving due respect to that 12% of the total number of members, you will anyway maintain register here. Copy of register, you can also maintain the registers at this place also. Are you understanding the point or not? So the idea is very clear. Keep the register at the register office, or if in any place, I repeat, if in any place more than 1/10 of the total number of members are residing, okay, so you have the register of members location available. Okay, 12%, there are 1 lakh members. 12,500 members in that 1 lakh are in Chennai. Okay, 12,500 out of 1 lakh is a good number for the company. Therefore, you can also keep the register in that other place, which is Chennai in our example. Are you understanding? So, sir, directly directors of the company can decide and place the register in Chennai. Yeah? No. Try to understand clearly. They have to pass a special resolution. Okay, means meeting should be conducted, special resolution must be passed, members of the company should say yes for this, then you can put the registers not in that particular place but in Chennai. So two conditions. Condition number 1, more than 1/10 of the total number of members must be there. Condition number 2, special resolution must be passed. As simple as that. Okay, now see the query. And moreover, who can inspect? Members say can inspect. Can directors inspect? No. Sir, I am a member and a director, or I am a director and member. Can? Yes, you can do that in member capacity. Is the answer for the second one. Let's see. First, you have to write the provision of law. As per section 94, the registers required to be kept and maintained by the company under section 88, and the copy of annual return file shall be kept at the, shall be, not maybe, kept at register office. However, such a register or return may also be kept at any other place in India. Indian again. Outside India, even 100% shareholders, if they say yes, also you cannot. Within India, you can choose different place. But in that other place, more than 1/10 of the total number of members should reside, and approval of special resolution is required. Sir, don't understand in a different way. So some people will write in exam, approval of 1/10 of the members is required. 1/10 members approval is not required. In that particular place where you are putting the registers, more than 1/10 of the members should reside in that place. Everyone understood? Everyone understood? I want a reply. Yes. So, Messrs. Techno Limited maintains register of members. That register is a group of members residing in Kolkata wanted to keep the registers in Kolkata. Group of members say they said they did not tell 1/10. You have to write answer in such a way. If that group represents 1/10 of the members in Kolkata, then yes, you can. However, special resolution has to be passed. Following the provision, register can be kept in Kolkata only if more than 1/10 of the total number of members reside in Kolkata and special resolution is passed. Right of a director. Can a director do that who is not a shareholder? No. So as per section 94(2), inspection of registers annual return can be done by members, debenture holder, other security holders. Okay, only those people can do. Shareholder, debenture holder, security holder, or beneficial owners. Director cannot make inspection into the records. However, if a director is also a shareholder, then he can do so. Okay, such a director is not a shareholder, thus he cannot inspect the register of members. The 6 marks question given in exam. You're clear with this? We'll go to the next question. Can we move on to the next one? Everyone say yes. Fast, fast, fast. And moreover, there are around 100 participants are there in live, but reply only by 7 or 8 people. What's going wrong? Are you listening or sleeping? Ah. Second part of the answer. Prithvi, you asked, na? Hi, Prithvi. Hello, no, బాగున్నావా? ఎక్కడ విజయవాడ చెన్నయ్య? Next one. Next question. Same kind of question, okay, with a chain, small chain, they asked again in exam. Due to heavy rains and floods, Chennai Handloom Limited was unable to convene its AGM up to 30th September. I said that 39 in the previous example, like that. He asked the question. So, up to 30th September 2017, it is unable to convene AGM. The company has not filed annual financial statements and annual return, as the directors of the company are of a view that since AGM did not take place, 60 days, etc. Same. You can write here, same as question 2. Sorry, not question 2. Question 3. Same as question 3. Okay, next. Next one. Answer the following question. The annual general meeting of KMP Limited has held on 30th of April 2015. Articles of Association of Companies silent regarding the quorum of general meeting. Only 10 members were personally present in the above meeting out of the total 2750 members of the company. Chairman adjourned the meeting for the want of quorum. Referring to the provisions of Companies Act 2013, examine the validity of the chairman's decision. Read the question. AGM of a company was held. Okay, meeting is held. Articles is silent regarding quorum. Articles did not tell anything. Why this sentence was there? Na? articles can ask for a more quorum, larger quorum than in the provisions. Okay. Out of only 10 members were personally present in the above meeting out of 2750. There is a slab count, 1000 to 5000, more than 5000. 1000 to 5000, 15 must be personally present. Only how many are present? Only 10 members are personally present. How many? 10 members. But there is a top-notch point here. What is the top-notch point? Up to here, everyone understood? Okay. So first you do one thing. Read this. First write about quorum. Quorum means the minimum number of members that must be present. Done. Next one. In case of, see here clearly, it is limited, means public limited. Public limited company ki slabs will apply. 100, 1000, 1000 to 5000 and more than 5000. Private limited company, 2 is the minimum quorum. That's it. So first you need to write, this is all the larger number articles can provide up to 1005, 15 and 30. Okay. So the point, annual general meeting is held on 30th of April and articles is silent regarding the quorum. 2750, a meeting has been adjourned. So will the meeting be adjourned or not? The answer is very simple. Whenever the quorum is not present. Whenever the quorum is not present. If it is 2750 members, 15 must be personally present. But only how many are present? Only 10 members were personally present. In this case, I kept gap only for you to write the answer here. Please write down the final answer here. The AGM shall be adjourned as decided by the board of directors, or if not decided, to the same day, same time, same place, next week. Okay, same place, next week. Chairman has no right to adjourn. Here, chairman's decision they are asking. Chairman per se don't have any right of adjournment. Adjournment rights are reserved only to the board of directors. If board do not tell anything when it will be adjourned, same day, same time, same place, next week it will automatically go. Okay. So please write down in a rough paper and attach it to the question bank, or if you have the question bank, write down this point. I did not give the answer here. So you have to remember this. That's why this point I did not include. So please write down the conclusion properly. If the AGM is, if the quorum is not present, AGM will be adjourned. But adjournment will be as per section 103. How it will be adjourned? Adjourned as per the board decision, time and place. If board do not decide anything, if they are silent, same day, same time, same place, next week. Okay. Chairman has no right of adjournment. These are the things you need to write down. Understood the quality of this question, everyone? Understood the point in this question or not, everyone? Okay. Next. One more question. State giving the reasons whether following statement is correct or incorrect. Quorum for general meetings for a public company where members are not more than 1000 is 5 personally present. Answer is yes or no? Yes. Public company 5, private company 2. Okay. But he is asking public now, therefore this is irrelevant. 5 personally present is right. Important question which came for 8 marks in exam. November 2018 question. Let's see. KMN Limited scheduled its AGM to be held on 11th March 2018 at 11 a.m. Okay. Company has 900 members and up to 1000. So 5 PP personally present. On 11th March, following persons were present by 11:30 a.m. What is the significance of 11:30? Quorum must be present within half an hour from the starting. If meeting starts at 11, quorum must be present within 11:30. Quorum section lone it was said. Okay. If quorum is not present within half an hour from the time appointed for the meeting, then the meeting will be adjourned. adjourned as per the board decision or adjourned to the same day, same time, same place next week. Okay. P1, P2, P3 were shareholders. Okay. First meeting was held. How many attended? P1, P2, P3, P4, P5. 5 people attended. P1, P2, P3 are shareholders. So 3 counted. P4 representing ABC Limited. P5 representing DEF Limited. Sir, what is this representing? Next, another one also there. P6, P7. These are proxies. So many points we need to present in exam now. How to write the answer? First, provision you have to write. Okay. In case of a public company, the quorum, if the number of members as on the date of meeting is 900, means within 1000, 5 persons must be personally present. Means proxies will not be counted. This is the first conclusion number 1. So P6, P7 irrelevant. Next, there is another section called as section number. This is a quorum section along with the normal members. There is a proxy section, section number 105. Okay, in that section 105 and other sections also, they clearly said that proxies will not be counted into the quorum. So they are deleted, they are excluded rather. Okay, we will not consider them. Now P1, P2, P3, P4 and P5. Representatives. Okay, section number 112, 113. 2 sections are there. 112, 113. 112 will be talking about governor and president. Okay. 113 will be talking about body corporates. I will give you an example. X Limited is a member in Y Limited. X Limited is a human being, a company, It cannot attend on its own. Therefore, it can send directors as representatives to attend the meeting. They are not proxies, they are representatives. Proxy don't have right to attend the meeting. They have right to attend the meeting, not counted for quorum. Okay. So proxies are not counted for quorum, but representatives are counted for quorum also. Representative is like a original member only. So you can consider him. So the conclusion is P1, P2, P3 present, P4, P5 counted because they are representatives, not proxy. So examine with reference to the relevant provisions of Companies Act whether quorum was present. First answer is yes, but don't write in exam yes sir. I will show you how to present. Just I'm summarizing the answer first. If you know the answer, you can present it beautifully. First, let us see. Okay, next. What will be your answer? What will be your answer? If P4 at P4 representing ABC Limited reach the meeting after 11:30 a.m. Within 11:30, if he is not present, okay, quorum will not be there because only 4 members personally present are there. Quorum, if not there, meeting will be adjourned as per the board decision to the same day, same time, same place next week, or as the board decides. In case of lack of quorum, okay, discuss the provisions applicable for adjourned meeting. Just now I told you that one. What happens if no quorum in adjourned meeting also? Sure. If in the adjourned meeting also quorum is not held, okay, if in the adjourned meeting also quorum is not held, what will happen? Meeting will be cancelled. Second adjournment about that section is not discussing. Section talks only about once meeting is adjourned, it will be adjourned to the same day, same time, same place next week. If again it was adjourned, in the adjourned meeting also quorum is not there, then what will happen? 2 things will happen. Whoever is personally present will become the quorum. If that is also not there, cancellation. But generally, whoever is personally present, maybe less than 5 also sometimes. Okay, 4, 3, 2 can also be there. That will form part of the quorum. So what is the last answer? If the quorum is not present also in the adjourned meeting, members personally present, okay, even though lesser than 5 will be taken as a quorum. So P1, P2, P3, P4 will be taken as a quorum. Very big answer. First you need to write the provision here. P1, P2, P3 will be counted as 3 members. If company is a member of another company, it may authorize a person through a resolution to act as a representative, and that representative shall be deemed to be a member and counted for quorum. Hence P4 and P5 will be counted. Only members present in person and not by proxy are counted. Hence proxies, whether they are members or not, will have to be excluded in the light of the provision of that. Like that, first you have to write the provision. After that, it can be concluded that then conclusion. The quorum of the AGM of KMN is 5 members personally present. P1, P2, P3, P4, P5. Hence the requirement of quorum is fulfilled. If the answer for the first query. Next. The section further states that the required quorum is not present within half an hour. The meeting will stand adjourned to the same time, same place, same time next week, or as decided by the board of directors, or such a time and place decided by board. P4 is an essential part of the meeting, the quorum requirement, and he reaches after 11:30, half an hour after starting, the meeting will be adjourned. If the quorum is not present, adjournment will be as per provision you have to write. But one point, whenever adjourned meeting happens as decided by the board shall give a 3 days notice before that. Next, if the quorum is not present in the adjourned meeting also, then members present shall form quorum. But minimum 2. Sir, members present only one member present, sir, then okay na. They said members, not member. Okay. Everyone give a clarity, understood? You say yes, we'll go into the next one. Everyone clear? Okay, next one. Examine the validity of the following with reference to the provisions of Companies Act 2013. The Board of Directors of Shrey Limited, okay, the Board of Directors of Shrey Limited called an extraordinary general meeting upon requisition of members. However, meeting was adjourned on the ground that quorum was not present at the meeting. Advise the company. Advise the company. Okay. What he is asking, again, question is on quorum, but this is an RTP question. Let us see the answer now. Please follow properly. Slowly, when the time is moving up, na, student will lose concentration. Please, exams are very near for you. Let's complete it on time. Okay. See here, what he is asking. Examine the validity of the following with reference to the board of directors of the company called an extraordinary general meeting. Okay. However, meeting was adjourned on the ground that quorum was not present. Advise the company. Okay. See here. If the meeting is adjourned, just now we read na, who can call EGM? Here two types of answers will come. He said that EGM called by members. There are two types of EGM. Okay. General, special cause. General. Two situations. Board of directors suo moto can call. Suo moto means what? They themselves wanted to decide something, they will call a EGM. This is one type. Most commonly happening. Sometimes members will request the board of directors and board of directors will conduct the EGM. This is second type. Third, members will request the board of directors. Board of directors did not call the EGM. Therefore, the members who requested, called as a requisitionist, will call the EGM. If this EGM is adjourned, same example again, same provision. Adjourned, board will decide when that place and time. If board does not decide, same time, same place, same time, same place next week, that will apply here. If board of directors did not call a meeting when requested by members and members got hurt and they called a meeting and in that meeting quorum is not present, adjournment will not happen, meeting will be cancelled. So here in the question, the concept clarity is missing. He said that board of directors called an extraordinary general meeting upon requisition. Here board of directors called. Now clarity there. Board called means it doesn't fall under second, it fall under first one only. Means what? Members requested, board of directors called, and that meeting was quorum not present. Therefore, they adjourned. How to adjourn? Same day, same time, same place next week, or as decided by the board of directors. Okay. So the point is what they have done. Let us see. Board of directors called an extraordinary general meeting upon requisition. However, meeting was adjourned on the grounds that quorum is not present. Advise the company. According to 102 of Companies Act, directors must call like that. In case of company having a share capital, who can call a EGM? Who can call EGM in case of company having share capital? Members on the date of receipt of requisition, not less than holding, not less than 1/10 of the paid up share capital, they can call. If company is not having share capital, 1/10 of the total voting power. So in simple logic, tell me, who can call a EGM? How many members? In case of company having share capital, members holding not less than 1/10 of the paid up share capital. Not having share capital, a guarantee company, total voting power 1/10 can request. If quorum is not present, okay, if quorum is not present within half an hour from the time appointed, if it is requisition of the members, then it shall be stand cancelled. When? If meeting is called by requisitionist. Therefore, meeting stands cancelled and the stand taken by the board of directors to adjourn it is not proper. Okay, means this was deemed by the ICA. This answer was deemed by ICA in such a way that though they clearly said that board of directors called an extraordinary general meeting upon requisition, they did this answer with an assumption that, okay, meeting called by requisition is. In that way they have answered. Why I have kept this answer to you? Because some controversial answers are given by ICA also. RTP, this particular answer is not that correct, because clearly he said in the question, board of directors called an extraordinary general meeting upon requisition of members. If board of directors call on requisition of members, okay, the board of directors called on the requisition of members, and if the quorum is not present, meeting will be adjourned. Meeting will be adjourned. But if the meeting is called by requisition is themselves, okay, since board has objected that, then the meeting will be cancelled. Then the meeting will be cancelled. But here they have given answer in a reverse way. Where? In the RTP. ICAI has committed a lot of mistakes with regard to some questions. I'm not telling every. Sometimes the mistakes happened. Therefore, if this question came in exam, sir, how to write? If this question came in exam, don't write this way. In the RTP, same answer is there. That's why I have no right to change the ICA answers. That's why I kept. But in exam, if the question come, how to present this? You have to write very clearly that EGM adjournment, EGM can be of two types. EGM called by board on request of members, EGM called by requisitionists themselves. This is not requisitionists themselves. EGM called by board on request of members. Here, adjournment is valid. But if the EGM is called by requisitionists themselves, then meeting will be cancelled. Okay. Actually, reverse answer should be there, but the ICA has given a answer this way. But in exam, please don't write this. In the exam, key answer will be different from this answer. So please write down that adjournment is valid. You want to see the provision really? See here once. I will show you the Fair Act of Companies Act 2030. See here. (103). Okay. See the Fair Act. If the quorum is not present within half an hour from the time appointed for holding the meeting shall stand adjourned to the same day, etc. If the meeting called by requisition is, then it shall be stand cancelled. Okay, then it shall be stand cancelled. The meeting shall stand adjourned to the same time. Okay, next, the meeting shall stand cancelled if called by requisition is. Called by requisition is not called by directors. Here in the question, directors called an extraordinary general meeting. Therefore, adjournment is valid. Okay, but in this, they have given reverse answer. Therefore, please write down here. Please write down here. Adjournment is valid since it is not the case of requisition is calling for the EGM. Okay, adjournment is valid since it is not the case of requisition is calling for EGM. Now everyone reply. Understood the controversial answer given by ICI? Why I am putting this question bank session is because of this. If you see the RTP, the same answer will be there, and student will get confusion. Sir, you said in the class that it will be cancelled only if it is called by requisition, not by board, but here answer is different. That's why. Everyone clear? Reply to what I said. So lot of mistakes have crept in, but later they rectified. But 2018, sorry, this is an old RTP question. In that they kept like this. Later they rectified. So rectified answer also I am giving you. Next. Question number 10. Answer the following. A shareholder of a company appointed B as a proxy. Appointed B as a proxy to attend the general meeting of the shareholders. Later on, A himself attended the meeting and voted on resolution. So simply, who is a proxy and what is a proxy? Proxy has two meanings. Proxy as a document, proxy as a person. Proxy is a person who attend the meeting, for a member to attend and vote on his behalf. Listen to my language first. Okay. Proxy is a person who is appointed by the member, to attend and vote on his behalf at the meeting. Okay, so he will be appointed for the member to vote on his behalf. Such kind of person we call as a proxy. So proxy is a person who is appointed for a member, okay, to attend and vote on his behalf. So now the concept is very clear. You are appointed for me. If I myself can go, you cannot vote again. Okay. So if I myself can go, you cannot. I have a doubt whether I will attend meeting or not. Therefore, I gave you proxy form. Okay. Proxy is of two types. One is proxy form. That's called as an instrument of proxy. The evidence that you are appointed as a proxy by a member. Proxy as a person is a person who is appointed by the member to attend and vote on his behalf. Okay. So now question. So first, proxy. Proxy may be defined as an instrument, okay, prescribed by the act by which a member of a company appoints another person to attend a meeting and vote on his behalf. And I myself is there, why you are voting on my behalf? Okay. But if the person appointed also attends the meeting and casts the vote, the proxies will stand cancelled. Okay. So therefore, in the present case, A's vote will be valid. So technically, priority will be given also only to the original member. Even if proxy voted, vote of member only will be counted, not of the proxy. Okay. So later on, A himself attended and voted on the resolution. Decide whether A can do so. Yes, he can do so. Okay. About this question, I will discuss it later because lot of discussions have to go inside. So selectively, another question I will take and I will do. One by one, let us first complete 4 marks questions. Finally, I will take the 8 marks questions later. First, I will cover all the 4 marks. Most of the times, 4 marks and 5 marks will come. So first, I will cover X. By the way, first, everyone, please give one reply. I'm not seeing your YouTube comments here. So, are you all clear up to here? Okay. X, a member of LKM Limited, is holding 250 shares, which are partly paid. The company held its general meeting where voting rights was denied to X, claiming he has not paid the calls on shares held by him. Examine the validity of company's denial to X with reference to the relevant provisions of Companies Act, assuming that the articles of association of company do not restrict the voting right of the members. Do not restrict the voting right. Do not. Okay. Do not restrict the voting rights. Listen carefully. I will explain the provision first. There is a section called as section number 106. As per section number 106, the following is the point. 106 says that whenever voting is there, every member has a right to vote. However, right to vote at the meeting will not be given to the members in two cases. Number one, if the member does not pay his call money properly, first call, second call, final call will be there. Na? Company called, but he is not paying. In that case, your right will not be given. Second, when it will not be given, it will not be given if company exercised the lien on the shares. Lien means what? This member is a debtor also. He is also a debtor. Listen, I can't repeat the question and answer every time. There is a member. Okay, that member paid calls properly. He did not pay dues to the company. He is a debtor. He purchased goods from the company, but he did not pay. Dues are there. He is not paying. Company, what it does? Shares are anyway there with the company or not. Your share control will be there with company or not. Company said that on these shares we are exercising the lien. Lien means what? We will give back you the shares if you pay the debts properly. That's called as a lien. So if calls are not paid or if lien is exercised on the shares of the member, in such a case, member has no right to vote at the meeting. However, company can do this only if it is promoted by articles. Means articles you should write in the following two cases. Okay, company can restrict the voting right to members. Like that, it should write in articles. Articles do not restrict. Means articles are not promoting it. Then company cannot do that even though calls are not paid. In the question, same thing happened. First provision. It states that articles of a company may provide that no member shall exercise any voting right in respect of shares on which calls are payable have not been paid, or company exercised right of lien. In the present case, articles do not restrict the shareholder. Okay, therefore, chairman at the meeting has no right to refuse him to vote. Denial to X is not valid. 3 marks. Next one. Examine the validity of the following decisions of the board of directors with reference to the provisions of Companies Act. In an annual general meeting of Vrinda Limited, having share capital, company having share capital, 80 members present in person or by proxy holding more than 1/10 of the total voting power demanded a poll. Chairperson of the meeting rejected the request on the ground that only members present in person can demand for a poll. Super RTP. Read the question. First. Don't see the answer. Sorry to say this, if you see the answer, you will get bad marks in the exam. Be sincere, be honest. Read the question first. If you want, you take a rough page and write your possible answer. Then I will give the main answer, you check the results. But don't see the answers. Now one question came in the YouTube, sir, but proxy voted and then member attended vote. Whose vote is valid? Member vote is valid. Have you read the question or not? Okay. So let's see the final answer. So the point, I will tell the answer first. First thing, whenever question comes, write something in the provision. Don't conclude the answer directly. First thing, it's a EGM. Okay, sorry, it's a general meeting. AGM or EGM, anything. Annual general meeting in the question. Okay. Can poll be demanded? Yes. Poll can be demanded in two ways. Number one, not demanded. Poll can be taken in two ways. Number one, chairman can automatically do that. Or members or proxy can also demand. Proxy cannot vote in the show of hands, but proxy can demand a poll. Proxy can vote by poll. So can proxy demand a poll or not? Yes, proxy can demand. 80 members are personally present and proxies are holding. Proxies are also there. Members, 80 members plus proxy holding more than 1/10 of the total voting power. Can they demand a poll or not? Yes, they can demand a poll. Okay, so therefore chairman rejected that members present in person only can demand. No, chairman's intention is and contention is wrong. poll can be demanded either by the member directly or even by the proxies who are representing the members. Next, first, section 109 provides that demand for a poll before or on the declaration of result by show of hands can be made. So from here the question and answer. Before or on the declaration or result of voting on any resolution by show of hands, a poll may be ordered or demanded to be taken by the chairperson of the meeting on his own motion and shall also be ordered to be taken on a demand made in that behalf. Okay. In the given case, a company having share capital by the members present in person or proxy were allowed and having not less than 1/10 of the total voting power or 5 lakh rupees sum. Here 1/10 is satisfied. Either 1/10 of the voting power must be there or 5 lakh rupees paid up capital should be there. Any of these two conditions you need to satisfy. In the given question, what is satisfied? 1/10 of the total voting power is satisfied. On the basis of our provision, chairman cannot reject the demand for poll as a poll can be demanded by members present in person or by proxy. Next. In an annual general meeting, during the process of a poll, members who earlier demanded for the poll wanted to withdraw it. Chairman of the meeting rejected the request on the ground that once poll started, it cannot be withdrawn. No, answer is again wrong. As per section number 109, it clearly said that poll can be demanded by members or by proxy holding not less than 1/10 of the total capital, total paid up share capital, voting power, or 5 lakh rupees in the paid up capital. Anything you can satisfy. Once demanded, it will be taken. Okay, once you demand the chairman, it will be taken. However, the demand can be withdrawn by the members at any time. Which member? Member who demanded the poll. Same member can also ask to retract means withdraw the poll demand which was made. First you write the provision. After that, the demand for the poll may be withdrawn at any time by the persons who made the demand. Who is that person? Either member or by proxy. Who demanded, they can also withdraw. Chairman cannot reject the request of the members for withdrawing the demand for. Clear? So this is the thing here. This is again a 8 marks question. I will discuss 6 marks question. I will discuss later. Now. First, let us complete the small type. These are all 1 mark, 2 marks questions. So first, let us complete. A special resolution is one to pass where the votes cast in favor must be twice the votes cast against it. Correct? Wrong. Special resolution, what will happen? Votes cast in favor must be at least 3 times votes cast against. So it is incorrect. A special resolution, same question asked in November 2015 also. See here incorrect because this is a 2 marks question. This is 1 mark. 1 mark correct, incorrect is enough. 2 marks ki explanation is also given. A resolution shall be passed especially when votes cast in favor, okay, either by members by show of hands or proxy, etc., shall not be less than 3 times the votes cast. That's what I said. Okay. Now, these are some questions that we considered in the today's session. Like this, consistently we will have the sessions every single day. 1.5 hours to 2 hours we will take every single day, and we will take up all the important chapters. Once general meeting is completed, next one is a General Clauses Act. One is General Clauses Act. After General Clauses Act, I will take FEMA. After FEMA, I will be taking accounts of company. Next, interpretation of statutes. Like that, all the core areas of our particular syllabus we are going to cover. Daily 1.5 hours to 2 hours. Consistently, you stay live in the YouTube, you listen properly, you will complete your syllabus in no time, your doubts will be clear. So since 30 marks of a crucial thing is there from the exam's point of view, I will first cover other laws. Once we complete general meetings chapter, I will take other laws and I will complete. Okay. Once other laws are over, then I will come to share capital and other things. Okay. Super 35 will cover all the important chapters. Small chapters I won't cover here. Main chapters covering 80 marks of your portion I will cover in Super 35. Clear everyone? Is the session useful for all of you? Yeah. Thank you very much. Meet you again tomorrow. Timings I will announce before 2-3 hours before I will announce. Okay. So all the topics, important topics, companies incorporate outside India, all the important things I will cover. So no worry for that. Okay. Thank you very much. But consistently be present in the live, complete it in the live itself, such that life will become very simple for you. Thank you.